Hello, hello. Okay, let's see. So we're gonna try to really make this very concise, very informative, very concise. Because I'm a little sleepy and my daughter's still here and I'll have to get up early in the morning. Okay, so we can do some things together. All right, I'm going to just pull up. I understand some horrible headlines, but we're going to stick to what we said. And we're going to talk about the man that was arrested for this guy right here. Okay, right there. I'm just going to pull up the papers here. So, and we'll read these. Okay. I'm just pulling up the document, sorry. Sorry. It's taking a minute. This Okay. There we go. Okay, get over there. All right, so this is the respondent supplemental record. State of Indiana, County of Carroll, State of Indiana, plaintiff versus Richard Allen, defendant. And this was the proceeding. Let's see here. Let's go over here. So this is going to be a transcript that we're going to look at from last month. Special Judge Francis Gull removed Baldwin and Brad Rossi from representing Allen due to the leak. Okay, that's why they were released from the case. I'm going to just go through that. And let's see. The Indiana man is behind bars because he disclosed sensitive information and evidence in connection with the 2017 Delphi murders. And his name is Westerman, Mitchell Thomas Westerman. He allegedly admitted to photographing the evidence with his phone and then sharing the evidence, which eventually made its way to podcasters and online communities. Investigators subsequently were given evidence from a podcaster that implicated Westerman. I observed printed copies of photo evidence on the conference room table. I took pictures of a few of them. Remember the leak in the attorney's office? Well, this is the guy, right? So let's take a look at this transcript, okay? Attorney McClellan says, Judge, I want to do some introductions. I finally got approval from our counsel to hire a paid attorney to help me. So court says, okay. Mr. McClellan says, small town, local government. So this is Jim Luttrell. He's a retired prosecutor from Grant County. He's decided or agreed to come on board. Court says, okay, have a seat. Mr. McClellan said he signed the oath to my office. Okay, the court says. Mr. McClellan says, and all that. I'm gonna handle a written, hold on a minute, doesn't want to, let's go, come on now. Okay, I'm going to handle a written appearance. Attorney James Luttrell says, nice to meet you, Judge. The court says, nice to meet you, Jim. Next week, Mr. McClellan said. The court says, okay. Mr. McClellan said, or maybe tomorrow if I have time, Judge, if I get it done. Court says, okay. Mr. McClellan says, but he will be entered in. We're trying to get him up to speed. The court says, okay, well, good. Attorney Bradley Rozzi says, well, I'm the one that kind of asked to huddle up. So if you want me to lead or if you want me to say some things, I'm okay with whatever approach you want to take here. The court says, go ahead. Mr. Rozzi says, well, I think, the court says, Jody's got our portable FTR going just so that Mr. Rozzi says, oh, okay, that's fine. The court says, got a record. Mr. Rozzi says, obviously, I'm happy to hear that the court's going to make some decisions on the pending pleadings today. The court, affirmative response. Mr. Rozzi says, I assume Andy feels the same way. It's time to kind of get some closure, if you will, with regard to those items so that we can move forward. It's probably obvious that the tension from our side is coming, from the words disqualification that were murmured in the phone conference that we had a couple of weeks ago. I'm assuming you understand how that kind of raises the intensity level of the circumstances, and I guess if I have a concern today, it's that, we're going to go out of the kind of in the public, so to speak, in the courtroom on the record and have a discussion about an ongoing investigation, and that's what I kind of gathered from this email. I think you invited Nick to talk about that if you wanted to. Mr. Rice said, and it makes me a little uncomfortable because I don't know, first of all, there are no pleadings that are pending, whether they're motions to disqualify or contempt citations or whatever they might be, that really frame any of the issues. And I have no problem. I don't have any problem talking about this stuff privately on the record in in an ex parte type confidential hearing. I just think it's it's difficult to expect that there will be any kind of structure to the idea of, hey, there's an ongoing investigation and just tell us what's going on. And I don't know that it has any relevance to what we're really trying to accomplish today. And I also don't know why Nick would want to talk about an ongoing investigation in public, knowing that in itself could be a little damaging to their circumstances. And so we're lawyers. We're used to having issues framed. We're used to having an opportunity to prepare. And I don't have anything to hide. And I know he doesn't have anything to hide. You maybe gathered that we've cooperated. We ran into the state police post, our respective posts. And I have somebody advise me of my rights, and I waived those, and I gave a formal statement, and he did the same. And I'm not sure that we're going to benefit or that this was going to be productive to just open the floor. And that's my biggest concern today. The court says, Attorney Andrew Baldwin, I'm more of the due process side. I'm not really sure what will happen, but I just don't know. I don't know what's going to happen, and I would like the opportunity to know what's going to happen and prepare for their claiming or whatever before it happens. And I don't want to say ambushed, but it's hard to know for me what to do when I don't know what's happening. There's not a pleading we can respond to, things like that. So, you had indicated that, when Nick said, I don't know if he said the word disqualification, but the court, oh, he did. Mr. Baldwin, what is that word? The court, was it that word? Mr. Baldwin said, the court says, Mr. Baldwin says, okay. I didn't know if he just said it in a more generic way. The court, negative response. And your response was, I'm leaning in that direction or something along those lines? The court. Mr. Baldwin. And so that's a cause of concern. I mean, we're still wanting to try this case in January, and I'm willing to. We've made changes at my office that will prevent this from ever happening again, and we can take directives from the court. We can, we're locking down every single thing on Delphi. It's in a dedicated room, and we put locks on all of our conference room or the war room where this guy went. My friend went in and did this without my knowledge. And no document, whether it's benign or something super, like a crime scene photo, is ever going to be left alone for a single solitary second ever again. So, I'm hoping that can be something the court, can say, all right, that's fine. And then let's get on with the trial, but I'll shut up now. The court, anything, Nick? Mr. McClellan, Judge, I guess my plan today was give the court a summary of the investigation. I've got witnesses here and exhibits to present, and then go towards the investigation. I'm more than happy to hand those over to the defense. I know it may harm the investigation, but I think it would be important that the court hear those things. I guess the heart of it, inaudible investigation, I think it's important. I think the importance of you hearing it is outweighed by that. And so I have those things. I'm concerned that the leak is not just a one-time leak. The evidence that we have shows it is an ongoing leak. However, it's being done, and it's just what's next. I have an issue. What's next? I mean, I spent the past 17 days investigating this night and day when I should have been focused on preparing for trial. And when I say night and day, I mean phone calls at 2 a.m., 3:30 a.m., night and day. And so that's where I'm at, Judge. Again, I'm an officer of the court. I'm reporting to the court what I know. And that's kind of where I see my role. The court says, okay. Mr. Rossi says, this is starting to scream due process to me. I haven't seen any of those exhibits, and I don't know really. Hang on a minute. This doesn't want to. Move on ahead. Come on. Spinning wheel. Here we go. Oh boy. Okay. I know being important for the court to hear those things. I guess the heart of it, inaudible investigation, I think it's important. I think the importance of you hearing it is outweighed by that. And so I have those things. I'm concerned that the leak is not just a one-time leak. The evidence that we have shows that it's an ongoing leak, however it's being done, and it's just what's next that I have an issue with. What's next? I mean, I spent the past 17 days investigating this night and day when I should have been focused on preparing for trial. And when I say night and day, I mean phone calls at 2 a.m., 3:30 a.m., night and day. And so that's where I'm at, Judge. Again, I'm an officer of the court. I'm reporting to the court what I know, and that's kind of where I see my role. Court, okay. Mr. Risey, this is starting to scream due process to me. I have not seen all of those exhibits, and I don't know really, frankly, I don't know about any of this, and I'm not distancing myself from Mr. Baldwin. I'm just saying I have no connection with any of these people, okay? And the idea that somehow the prosecutor is going to get to roll out a bunch of statements and exhibits and testimony without us having any forewarning or any idea, any way of scrutinizing that seems a little outside the boundaries of due process to me. Plus, again, I get back to what is relevance to what is going on in this case. Why are we going to use an open courtroom to air an ancillary matter? It's not really connected in any way at this point to the proceedings that are ongoing, whether it's the Frank's issue or anything of that nature. And I will tell you this, and I'm prepared to show the court this. I would rather do it in private. This problem has been a problem from the very beginning. I have 10 pages of a deposition transcript in this file from my deposition, our deposition that I took of Trooper Holman in this case. And in that deposition, he talks openly about how there were crime scene links from the very beginning, unequivocal crime scene links, and that as soon as this crime occurred, they were investigating information that had been released because they were lay people that were part of the search party. And the implication is, and I've got the transcript, is that those people that found those girls started to essentially disseminate or distribute information, and law enforcement essentially tried to catch up with them. But it was really too late, as you might expect. Once it gets in the hands of the public, it's too late. So he told us that, almost volunteered that information to me in the deposition. The second concern I have is that I think I shared with the court, just as an example, a week or two ago, somebody sends me a court TV, bit, and I can assure you I've never watched one of those bits on this case. I don't even know if I've ever even watched court TV. Maybe back when Simpson was ongoing. I don't know. And in that bit, Barbara McDonald is talking 2 different occasions. She mentioned how she's getting information from investigators on the ground that was at this crime scene. Now, we can all draw implications about that, but most importantly, it was corroborated by the fact that she was holding in her hand documents that I know to be directly related to the Purdue report. I mean, I saw the pictures. I know where those came from. And if you know, the point here is, and I'm going to say this maybe a little loosely, but forgive me, I don't care. I don't care that all this stuff is out there because it's been out there for 5 or 6 years. I don't have time. He doesn't have time. He doesn't have time to sit and try to marshal all of this stuff while the case is ongoing because there's no end to it. But the point is the court needs to have some context that this is nothing new. I'm super high lost sleep over the fact that there's a man who's dead that I don't even know. And frankly, Andy doesn't know. And it's tragic. I don't know what life circumstance he had or what surrounded this. None of that information has been shared with us. But at the end of the day, what's going on out in the cyber world and in the public, as you might expect in the case of this magnitude that's been publicized for 6 years, was beyond our control before we even got involved. Mr. Baldwin, there's even a guy in Florida who says the guy in Texas who leaked all this stuff has received from disgruntled Carroll County employee a whole file filled with stuff and photos included. And haven't seen the photos that were leaked. I don't know where they are. If this could be set for a formal hearing in the future where we have a chance to do it the right way, then that's one thing. But to go in there and we don't have any counter way to counteract anything. If I know what it is, I can, I know what it is, or I don't know what that is. And it's, and in the meantime, we can, honestly, this is the lowest point in my career right now because somebody did what they did to me. And this has nothing to do with Richard Allen. The court, it certainly does not. Mr. Baldwin, Richard Allen needs to have counsel there. So I just don't want to go in there and not be able to fight back with evidence that or witnesses that we have to counteract whatever they claim that they have. So the court says, okay, here are my thoughts. In no particular order. I don't know how many folks are out there, and I certainly don't wish to air publicly to the world concerns that I have about this matter. My intent is having this hearing was to go through some of the pleadings that we have not yet decided. So I was going to start with reminding everybody about the decorum order, reminding everybody why we're here, to shut up, etc. There have been reports to my sheriff about disruptive people, and I will remind you, if they are disruptive, they will be removed. And my sheriff is fully prepared to execute arrests if necessary, because I know we've seen in other hearings people have been disruptive and hateful. So under the rules, under the canons of judicial conduct, I'm required to advise people within the room that the media is here and they are filming. They're doing pool coverage, so there's only 2 cameras in the courtroom, and everybody's going to get coverage from that. And then I want to talk about the pleadings. Defendant filed a verified motion for immediate transfer of custody. The state filed its response. The motion, again, has a lot of inaccuracies and some speculation, and it has been refuted ably, I think, by the affidavits that have been submitted by the state, and I'm going to deny the motion. The defendant then filed a motion for a broadcasting order. The state filed its response. Your motion's overbroad. It's got a lot of irrelevant verbiage in it, and I am required to consider individual requests for hearings, so I will. If the media wishes to have an individual request for hearings, so I will. If the media wishes to have an individual request submitted, they know fully well how to do that. And I provided to counsel all of those requests that I've gotten so far for this hearing. So if you want to file them for particular hearings, you're certainly welcome to do that. But the media is all over this, and they know how to do this. Mr. Razi. Yeah, I was just trying to understand. Are you suggesting that you're going to determine that on a case-by-case basis or a hearing-by-hearing basis? The court. Hearing by hearing. Mr. Razi. Okay. The court. Yeah. Mr. Razi. All right, okay. I just want to make sure I understood what the court. The state filed its motion for a leave of court to subpoena the third-party records. I think that was directed again to DOC. One clearly can't grant that. I'm going to grant the defendant's motion to quash. But if you continue to raise his medical and mental health in proceedings, that's fair game then for that to be provided to the state. You have also filed, Mr. McClelland, a motion for future proceedings and filings to be sealed prior to being released. What happened here? To the public. I've gotten a response from the defense. Mr. Razi, can I speak on that? The court. Sure. Mr. Razi, I think it's important to note that, we had this discussion come up before, and there was basically, we decided, okay, we're done sealing stuff. We're going to make it public. Before we filed the Frank's brief, I had a long conversation with the court reporter Karen Allen over in Delphi. That's funny, the court reporter's name is Karen Allen. Because I wasn't sure about Allen or Roller. I always wanted to call her Karen. Mr. McLeland, Allen, Mr. Rossi, Karen Allen, because I wasn't sure about the mechanics of how all this stuff was moving from Delphi to your office. And I know that you had set up some kind of website or something that people could access. And I was under the understanding, and speaking with Ms. Allen, I'm not blaming her for anything, but that when we filed these things, they were going from them and they were hitting a button, and we were filming with Carroll County and they were hitting enter and they were sending it to you, and you were essentially filtering this stuff, or at least you were seeing it before it became public. The court? Nope. Mr. Rossi. And so that's the way in talking with her, that's the way I understood the mechanics, which I thought is what happened to a pleading the other day, from what I understood. We filed something that you either put in a queue. I think anyway, I tried to do some homework on that, and that's Mr. Baldwin, I was a part of one of those conversations, and that's what she said. The court. Does that need a hearing? I'm happy to have a hearing on that. I don't have a problem with that. Mr. Rossi, well, I don't really, I guess I'm just telling you for context, that's what I mean, Mr. Baldwin says, could there be a happy medium of we file if confidentiality, and then, excuse me, I can't even speak tonight. Could there be a happy medium of we file it confidentially, and then the judge then gets a chance to review it first, because that's what we thought was going on anyway. But if that's not going on, court says, no, it's being filed confidentially if you mark it as Volume 1, page 12, Mr. Baldwin. I know that now. Court. I had my staff mark the memorandum confidential after it's been filed and disseminated to the public, because the actual warrant was in there, and that's covered under a miscellaneous case number. I'm happy to have a hearing, Rossi. Well, what is your ruling? Guess to make sure I understand, I don't want to fight about something that we don't need to argue about. The court. I haven't ruled on that. Mr. Rossi. Okay. The court. You haven't filed a response in that. Mr. Rossi. Yeah. The court. My question is, do we need a hearing on that, or do you wish to file a response? The Franks motion clearly needs a ruling, and I'm working on that. The motion and exhibits are about 1,500 pages. And are hours and hours and hours of interviews that have been made available that my IT staff now has cleaned to make sure they're okay. We already talked about that. And then, this brings up us to my concerns that I raised with all of you on our phone call, and I write everything out, and this is what I intend to say in open court. I have concerns regarding the defense team and the totality of the circumstances surrounding your representation of Mr. Allen. Candidly, my concerns began at our hearing on November 22nd of last year. Mr. McLeland followed a motion for a gag order, and we were in chambers, and you assured me, gentlemen, we don't want the media in our lives. We will not try this case in the media, and less than 2 weeks later, you issued an undated press release that contained an awful lot of information that would not normally be revealed. I don't know. I think you knew, or you should have known, that there were potentially violative of Rule 3.6 of the Rules of Professional Responsibility, but it is that press release that prompted me to issue the order December 2nd, granting the gag order until further hearing. April 18th of this year, you filed a notice of tort claim against the Department of Correction. You stated in that notice that it was your intent to pursue our client's claims against you. The full amount of damages sought on behalf of my client is unknown. I don't know how you could do that in representing Mr. Allen in a criminal matter and then launch off into a civil matter. I think that's inappropriate. May of this year, we were notified by the state of the Brandon Woodhouse arrest and the subsequent discovery of your work product, and I think it was an outline that you created for yourselves with the discovery. It was pretty detailed. I don't know if that's the right word. That apparently happened in December of last year, and that was not revealed to anybody, not shared with the court. It wasn't shared with you, although apparently you guys knew what was going on. Mr. Baldwin, he didn't know. The court, you knew. Mr. Baldwin, I did know. The court. So then Mr. Woodhouse gets arrested, and here we are, grossly negligent, to email that to the wrong Brad. Your pleadings on the safekeeping order contain inaccuracies and falsehoods. That was proven in the hearing we conducted in June. The evidence presented by the state clearly demonstrated the falsity of your claims, and that was very troubling to me. And then, the last couple of weeks that we have been dealing with, the state provided you discovery that has been severely compromised. We now have an ongoing investigation. I'm going to call it a criminal investigation. I don't know what it is, but it's clearly being investigated by the state of Indiana. Everyone involved has sought counsel, including you, Mr. Baldwin. You had an attorney enter a written appearance this morning. I don't want to get into the investigation, candidly. You are the constitutional authority for the state of Indiana. If you chose to pursue it, then it's up to you. If you chose to abandon it, then it's clearly up to you. I'm glad to hear that you have cooperated, but Mr. Baldwin's attorney has clearly shared, I don't know, if you've seen his pleading. Mr. McClellan, I saw it, Judge. Yes. I got it kind of late. He emailed us, and then the court. Okay. Mr. McClellan, I saw that was filed on the way here. Well, yeah, the court says. So he's clearly shared it in the pleading, down to the fact that this individual has committed suicide. He included the fact that you left materials all over a conference room table, accessible to anyone. And this is a friend of yours who apparently you have consulted with on this case. So again, it's up to you if you wish to pursue that. I'm looking at the totality of the circumstances. You know, when I look at suppression, the case law requires me to look at the totality of the circumstances, and that's what I'm doing. And it pains me to say this, but the totality of these circumstances demonstrate gross negligence and incompetence on the part of the defense team. I am unsatisfied with your representation of Mr. Allen. I am gravely concerned about his rights to have a competent, non-negligent representation. He currently doesn't have that right now because what you have demonstrated is negligence and incompetence. Now I am sharing my thoughts with you privately. I don't want to say this in open court. I would encourage you to talk privately about what you wish to do. I don't want this coming out. It is not where we need to be with this case, but I will. But you don't know that. You have now just been made aware of my concerns and where I'm landing. So if you wish to have a private conversation, I would encourage you to do that. I don't believe your client is here yet. No, he's not. Clearly, you need to speak with him as well. So Mr. Baldwin says, I'm not good at reading between the lines. The court says, you're a lawyer. That's what you do for a living. Mr. Baldwin says, when you say have a private conversation, are you talking the four of us? Court says, I'm talking about you. I am not accusing the state of gross incompetence and negligence. I am finding gross incompetence and negligence with you. Mr. Baldwin, so Mr. Rozzi, forgive me, go ahead. Mr. Baldwin, no. Mr. Rozzi, I mean, obviously, reading the tea leaves here, what you're giving us a chance to do is bow out gracefully, if you will. If that's the right term, if is there a scenario where the court would accept if I stayed in the case? I mean, I'm not. I'm a team player, and I'm not the kind of guy to just bail out on somebody just for the sake of doing it. But I think it's obvious that, he can speak differently, but I'm not as connected to some of, this most recent circumstances as he is. Mr. Allen is in a situation where he's going to have counsel that's, if he has new counsel, it's going to take them a year to get up to speed with the depth of information that continues to come in. And so I think that his Sixth Amendment rights matter. And, I'm probably the one that can at least move this thing forward with some sense of judicial economy. I don't like it, and that's not what I intend to do when I came up here today, but that would be kind of the worst case scenario from our side, I guess. And so that is an option that the court would entertain. The court, no. Mr. Razi, so basically what you're saying, you guys either quit on your own accord, or you make me fire you. That's what the court, no. I'm saying to you that this is what I plan to say in court on the record when we convene at 2:00. Mr. Razi, well, is the culmination of that you're going to be, that you're removing us from the case? The court, I will. Excuse me. Based on what I've just shared with you, Mr. Razi. Okay, well, I just want to make sure we're the court, and I'm just giving you the opportunity to have a conversation, which, how do you want that to go? I don't want to do this. I don't want to do this, but I will if I have to. Mr. Baldwin, should we bow out gracefully, as Brad says? How would we even have a hearing? How would that go? Because if we're out of the case, then, Mr. Razi, then you're going to go ahead and rule on a bunch of stuff without lawyers in the room? That's the court. No, I would not do that. If you decide that your best, hold on. Course of action is to file a motion to withdraw. You can do that today, and I'll send Mr. Allen back to DOC after you've had a chance to speak with him. Would that happen, Mr. Baldwin says, before the hearing or after the hearing? The court says, your motion to withdraw would happen before the hearing, Mr. Baldwin. Okay, that's what I wanted. The court, yeah, because he has rights, and I don't want those rights compromised by having a hearing with him, not having counsel. I assume if you choose to withdraw, that his financial situation hasn't changed, and he would still be entitled to court-appointed counsel. I can't imagine that he has the ability at this point to hire counsel. I don't know that. Mr. Baldwin, Brad and I need to go talk. The court, yes, you do. Thank you, gentlemen. Mr. McClellan, yep, thank you, Judge. The court, thank you, Jody. Court reporter, you're welcome. The court, okay, yes. Mr. Razi, all right. So obviously we're kind of trying to figure out how to address this issue with very short notice, very little notice. The first thing we did is really talk to the court. Affirmative response. Mr. Razi, our client is a big part of this, the biggest part of this. And he has communicated to us that he does not want us to withdraw from this case. He wants us to continue with his representation. He understands, I think, that he's not the gatekeeper, or he doesn't have the authority to really force the court to do that. He would like to say on record, we asked him if that's what he wanted to do. We suggested maybe he would do it in chambers. It seems a little more difficult position to put a man in who's been accused but not found guilty. Put him in a courtroom and have him, have him to speak this circumstance with 15 minutes notice. Andy and I'm going to speak for myself. I'll let him speak for himself. I'm going to file a motion to withdraw. I don't want to do it, but I don't think that I have a choice at this point. The options I've been given without any notice by the court really are either one, withdraw, or I'm going to be publicly shamed, and that's the way I see this. And I think that public shaming is there's not only a professional element to that, I think there's a personal aspect to that too. But when the media is teed up like this, and we show up here today with the court having told us that we were going to conduct some business, and that somehow bleeds over into a forced resignation or whatever you want to, however you characterize this, that I don't feel like I have any other choice professionally. I have a life beyond this courtroom and beyond this case, and I have a family too, and I have a law practice. But I think we had been given some notice of what we were actually. If this would have been framed in a pleading format or some formal disciplinary claim where there's a process for that in our business, then we could have come in here today with an opportunity to refute some of those things that you clearly had, thought through and prepared before we got here, and we didn't have that opportunity. And it's the idea that I'm going to have to go in there in an open courtroom and essentially defend myself against claims that I don't agree with, without any notice and without any opportunity, I think is unfair. But I also have some common sense, me going in there and standing my ground because my client wants me to is just going to make things worse for him. So I'm going to withdraw my appearance. I'm going to walk out of here. I'm going to go down to my car. I'm going to call my staff and have them prepare a motion. And I'm going to withdraw my appearance. But I'm doing it because I don't think I have any other choice professionally. Not because I want to. And not because my client wants me to. And I respect the court as an opinion. But we're professionals. And we can disagree. The court, of course. Mr. Rossi. And I am extremely, I'd say frustrated, probably a soft word, with the idea that we showed up today without any real opportunity to prepare for any of this. And I just think that it's improper, and that's where I am, and that's my position. Court. Well, I think we talked about when you asked for a disqualification, and I indicated on our phone conversation, I'm inclined to do that, Mr. Rossi. It was a phone conversation that was not on the record, and then some follow-up emails. The court, true? Mr. Rossi, that's an informality to me, to that. There's an informality to that. The court, true, Mr. Rossi. And you also said that you hadn't even done your research, and you hadn't, had the time to talk to your senior judge and all those other things. And he hasn't filed a pleading with the court either. The court, no, I'm doing this on my motion. Mr. Rossi, and I'm a lawyer who practices in lots of courtrooms, and I've been through some disqualification actions. In 20 years, I've never had a disciplinary complaint in my life that's been confirmed, if you will, but I've seen lawyers disqualified, and there's a process for that, and it's not this. With all due respect, when you walk into someone's office, a judge's office, and they read a prepared statement to you, and essentially the statement is an indictment on my professional, activities, and then you're handed essentially a sheet of paper with two options, and one of them is, I'm going to go out of here and shame you, or you could quit. And you can understand how upset that would make any lawyer, and I just think I don't think it's the right way to handle this from a due process standpoint. So I have no choice but to, withdraw my appearance, because I'm not going to go out there and take a public shaming without having any notice of it. I just, that's where I am with it, Mr. Baldwin. I'm the same, withdrawing. I mirror what he said. I mean, I do appreciate giving us the advance notice. If there is some appreciation for that, I do appreciate that. But beyond that, I wanted to take this, and finish it out. I'm stunned. I don't know what to say. So I'll just say I'm moving to withdraw orally. The court, okay, Mr. Rossi. Is the court going to generate some further instructions on what to do with all of this discovery that we have? And the court, I already have. Mr. Rossi, all this information, and the court, there's an order. I granted the state's protective order on discovery. No, I'm talking about my possession of all of this information. Am I going to take it to the trash can? Am I supposed to wait for another attorney? Is the court going to give us some guidance on how to move all of this information from one law office, the court? I did, Mr. Rozzi, to another, the court. When I granted the state's protective order, I think it's the last paragraph of that protective order, directs you to return it all to the state of Indiana. All the copies, all of the, whatever you gave them, they are required under that order to return to you, Mr. Rozzi. At the conclusion of the case, the court, or your representation, Mr. Rozzi. I know what order you're talking about. I read the order before I came today. Hold on a second here. The court. Okay. Mr. Rozzi, so we're supposed to take everything back and give it to the state and then just retain our work product until somebody asks for it? The court. Your work product is your work product. I mean, I would hope that you would share that with successor's counsel. I would hope that you would help successor counsel just with the transfer of all the information, because that's in your client's best interest to do that. But that's entirely up to you. That's your work product that you have developed. I mean, clearly the discovery is required to go back to the state. Mr. Rozzi, okay, thank you. What do you want to do with Mr. Allen? The court, I can transport him back to the Department of Corrections. Mr. Rozzi, do you want to make a record with this? I mean, I think it's appropriate that the court let him speak into the record his thoughts, unless the court just accepts that as notice that those are his opinions. The court, well, you wouldn't lie to me about that. Mr. Rozzi, I would not lie to you about anything. The court, so of course, that's your representation. That's what he would say if he were brought in here. I can't imagine the DOC being comfortable bringing him into my office. I would not be comfortable having him in my office. Mr. Rozzi, would the court also be inclined to mark as an exhibit the prepared statement so that part of it, so that's it's part on the record, of the record? The court, I have the record rolling. Mr. Rozzi, okay. The court, yes. So we're going to leave, I guess, and you're going to, how is this? You're going to get up on the bench and say, the court, I will just indicate to Mr. McClelland's going to be in there with Mr. Luttrell, and I'll say, we've had a turn of events and defense counsel is withdrawing, and that's all I'm going to say. Mr. Baldwin, can you wait for us to get out of here? The court, of course. And we can have, I don't know where you're parked at. We have a hearing set for October 31st that I'd like to keep as trial setting and appointment of new counsel. And if you can get things together by that date to return to Mr. McClelland, that would be good. Otherwise, if, with your permission, I will give successor counsel your contact information. Mr. Baldwin and Mr. Rozzi, okay. The court, where are you parked? Mr. Rozzi, nice to meet you. Sorry to Mr. Luttrell, inaudible. Mr. Baldwin, just right out there in front of the building. I mean, there's a parking lot. There's a little parking lot right in front of the building. I don't know what the court. Everybody's in the courtroom, so I don't think that there's anybody out in the hallways. Mr. Rozzi, I'm going to get my staff member. I'm going to have her. I don't need any. We'll rendezvous at some point and try to get the stuff back. Mr. McClelland, okay, that's fine. Between Steve and I and Sarah and you. Mr. Rozzi, okay. Mr. McClelland, we will get it all. Mr. Rozzi, that's fine. Mr. McClelland, done. That's either Sarah, thank you. The court, thank you. This concludes the proceedings had in camera on October 19th, 2023. Certificate of the reporter. Okay. So that's the deal there. They've got the guy who apparently was a friend who went into the conference room, took the pictures, was arrested, and then that's how the attorneys are off the case. They didn't want to be off the case, but felt they had no choice because the judge was going to publicly shame them, and they didn't want that. So that's about that, what the evidence like. And now it's time for word cookies because I want to go to bed. I want to go to bed. I don't know where you guys are, but I'm going to put the word cookies on. I don't know where you are. That's so interesting. I don't know where the live is. I don't know where the live is. It's coming on. I really do wish I could find a live. I really do wish I could find a live. Oh my goodness, what is going on? Oh my gosh. There's word cookies, but I don't know where. Chrome shut down, so I have to open it up and get you guys. Come on, buddy. Trying to get you back. Trying to get you back. I'm almost there. I'm almost there. Here I am. Okay, I'm back. So hi, Elizabeth. I have to leave, sadly, before word cookies. Elizabeth, no. Hi, Barb Olson. What are you bothering Elizabeth, Scooter? What are you bothering Elizabeth with? That you're making her tag you? What are you doing, Scooter? Exactly what are you up to? Sorry, Elizabeth, that you can't be here to play with us. We'll miss you. Heart midwife. Hi, Emmy. I thought I already had tort. Okay. Torta. Daughter. I tried daughter. Doesn't work. I got it. I'm beyond rotted. Rotted, yes. Okay. So it's rotted. A tower. It has to start. It has to start with a T. I tried toted. It doesn't work. I tried toted with one now. See? It's with two T's. Toted, not toted. Okay, two T's. Very good. Toted. Okay. We're done. Oh, what a night. What a night. See if we can get this one. Oh. I saw that one now. Yeah, you could look at it again and get it. Okay. 100 coins. All right, I'm going to bed. Good night. God bless. Prayers. Thank you guys. Have a good night. 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 Good night.